Philosophy 212, Ethics in Business and Society. Sexual harassment is an important issue that touches on various areas in ethics in business and society. In this lecture, we will primarily look at issues related to law and business in regards to sexual harassment. First, we will define sexual harassment. Then we will look at a landmark Supreme Court case regarding this issue. We will also touch on some practical advice for listeners. Finally, we will discuss impacts of sexual harassment on business interests. Sexual harassment is uninvited and unwelcome verbal or physical conduct of a sexual nature. Note a few things important to this definition. First, sexual harassment involves behavior of a sexual nature. Second, this behavior can be verbal, in the form of words such as lewd comments or dirty jokes, or physical, such as touching. Very important to the definition of sexual harassment is that the behavior in question is uninvited and unwelcome. It is uninvited in the sense that the person being harassed is not asking for it. It is unwelcome in that the person being harassed does not want the behavior to be occurring. Turning to the legal perspective, we look at the landmark Supreme Court case of Merito v. Vinson, which was decided in 1986. I will briefly discuss the details. You should turn to the assigned readings for further information. Initially, Michelle Vinson sued Sidney Taylor and Capital City Bank for sexual harassment. Vinson alleged that Taylor, her supervisor, had subjected her to sexually harassing behaviors of various sorts over a 2.5-year period. Taylor denied the charges. The case made its way through 3 courts. First, the D.C. District Court ruled that if there was a relationship between Vinson and Taylor, that relationship was voluntary, so Vinson was not a victim of sexual harassment. Also, the District Court ruled that the bank could not be held liable for damages, since the bank had a complaint system and Vinson never used it. Vinson and her legal team appealed the decision to the Court of Appeals, which reversed the lower court's opinion. The appeals court noted that there are 2 kinds of sexual harassment: quid pro quo and hostile work environment, and Vinson had been subjected to the second sort. It was therefore irrelevant whether Vinson's compliance was voluntary. What mattered was that Taylor's behavior was unwelcome. Finally, the appeals court held that even if the bank did not know of the harassing behavior, the bank was still liable for damages. Having lost the second round, the bank appealed to the United States Supreme Court. This is the highest court in the land and determines the law for all. The Supreme Court decides ultimately, for all courts, what the law means and how it is to be applied. Here is how the Supreme Court ruled, setting much of the law on sexual harassment to this day. First, the Supreme Court agreed with the Court of Appeals that there are 2 kinds of sexual harassment. Quid pro quo sexual harassment occurs when employment-related consideration is offered in exchange for sexually related behavior. For example, a supervisor may suggest that an employee could get a raise if she allows him to touch her sexually. A hostile work environment, on the other hand, occurs when a situation at work is such that sexual conduct is troubling to an employee to the extent that they cannot successfully do their job. For example, a supervisor could make frequent comments about an employee's appearance in a sexually suggestive manner. Here, there are no employment-related considerations. On the issue of consent, the Supreme Court ruled that consent was irrelevant. That is, it did not matter whether Vinson voluntarily went along with Taylor's behavior. What matters was that she thought she had to go along in order to keep her job. Consider an analogy. Suppose I am mugged and I voluntarily give my valuables to the mugger. Even though I consent to giving up my valuables, I do so under duress. But it would be absurd to say that I was not mugged just because I gave my consent. Finally, on the issue of employer liability, the Supreme Court ruled that the bank could not be held liable if they did not know about the behavior and they had a workable complaint system. While it is true that the bank had a complaint system and that Vinson did not use it, the system was not a workable one, since it required Vinson to complain to her supervisor, the very person who was alleged to be harassing her. Therefore, the bank could be held liable. It is important to note that the Supreme Court settled the issue that sexual harassment is a civil rights issue. Sexual harassment violates Title VII of the Civil Rights Act of 1964. It is a form of discrimination against someone because of their sex. It is claimed that sexual harassment has been used historically as a means to subject women to male domination in the workplace, just as racial harassment has been used to subject other minorities to domination. Turning to our reasoning from perspectives, we see how we can reason from the very general principle, obey the law, to the more and more specific principles noted on this slide. It is important to note that the courts in Meritor v. Vinson were unable to determine whether any sexual harassment actually went on. This is because they had no evidence one way or another. It was a classic she said, he said scenario. With that in mind, here's some practical advice for the listener. If you or anyone you know is subject to uninvited and unwelcome conduct of a sexual nature at work or elsewhere, say no. Let the person know that the behavior is unwelcome. Document. If the behavior persists, keep records on what happened, when it happened, if there were any witnesses, etc. Complain. Take your situation to the designated person who handles Title VII complaints. Get a lawyer. If the situation is not resolved to your satisfaction, you should seek legal counsel to advise you on your next step. The issue of employer liability takes us to the business perspective. From the business perspective, sexual harassment is wrong because it can lead to loss of profits. This can happen in one of many ways. Lawsuits can be very damaging to a company's bottom line. A public sexual harassment story can be damaging to the reputation of a business, causing loss of sales, lowering of stock price, etc. Finally, employee morale can be hurt by a work environment in which sexual harassment goes on or is tolerated. Productivity could suffer and good workers could be lost. We have covered important legal and business issues related to sexual harassment. Issues elsewhere.